last class we had started off with consideration, the meaning of consideration according to the Indian Contract Act, and we looked at the first essential, that consideration may be past, may be present, or may be even future consideration. So today we'll be looking at the second consideration or the second essential of consideration. It need not be adequate to the promise. It is nowhere laid down that the consideration should be adequate to the promise. Now here what the second essential is talking about is that adequacy means what? Equal to the power of, correct? Equal to or to the power of. Now here the point is telling us that the consideration, whatever you're getting in return, it need not be equal to the promise, or it need not be to the power at the promise. Then what is it? Adequacy is for the parties to decide. So it is up to both the parties who are entering into the contract to decide about the consideration. It may be equal to the promise or it may be lesser to the promise also. Doesn't matter. Consideration is just something in return. It does not say something in equal to the promise. The Act never says that. Act only says something in return. So no contract cannot be refused on the grounds of inadequacy of the consideration. So if there's any two people entering into the contract, all the terms and conditions are fixed by a mutual agreement between them, and then later one of the party goes to the court of law filing a case saying that the consideration was inadequate, then the case is going to be void in the court of law, because the Act, Indian Contract Act, says the consideration need not be adequate to the promise. It is just a mutual agreement between both the parties. You agreed to pay so much, or you agreed to receive so much of money or something in return, and now you cannot come to the court of law and says what you have received is inadequate. Hope you got the point. Let's look at the example for better understanding. A agrees to sell his house worth rupees 10 lakh to B for rupees 10,000. Now, who is willing to sell? A is willing to sell. For what is he selling? House. What is the worth of the house? 10 lakh rupees is the worth of the house. But how much is he willing to sell for? 10,000 rupees. Now, is this equal? The house worth is 10 lakh rupees, but he is ready to sell it for 10,000 to Mr. B. Is this adequate? No, it is not at all adequate. It is not equal, or it is not equal to the power of the worth of the house. But yet, A has agreed to sell it and B has agreed to purchase it at rupees 10,000, the house which is worth for rupees 10 lakh. So, as the consent of the agreement was freely given, the agreement is contract. Notice that word, as the consent. That means A was not forcefully asked to reduce the price to so low. Where is 1 lakh and where is 10 lakh and where is 10,000? He was not forced to do so. It was a free consent. That means he by himself agreed to it, and B also agreed to purchase it for rupees 10,000. So consent of the agreement was freely given. There was no caution or there was no induced influence, etc. It was freely agreed by both the parties to the contract, that is A as well as B. Therefore, the agreement is a contract in the eyes of law, notwithstanding the inadequacy of consideration. If you or me would have to look at this contract, we would say that's not right. He's selling a house worth rupees 10 lakh and Mr. B is only paying 10,000. This is not really right. We are nobody to judge the case, because A has freely given the consent worth rupees 10 lakh to be sold at rupees 10,000. So nobody else can question this consideration, because the law itself says it can be inadequate. Okay, there's no particular or there's no compulsory from the court of law that the consideration must be adequate. That's why the court says it need not be adequate. It's okay if it's lesser than the promise or more than the promise, as long as both the parties are giving their consent freely. Is that clear? If both the parties are agreeing to that price, then there's no other person to question about that contract. Hope you've understood the point. Consideration need not be adequate to the promise. Moving on to the third one, it must be real and not illusionary. Although the consideration can be past, present, and future, and also need not be adequate, but it should be competent, real, and valuable in the eyes of law. It should not be unreal or illusionary. Now, as we say, it must be real means you cannot enter into a contract by giving fake promises or something which is unrealistic in nature. Naturally, it is impossible to perform, but you are entering into the contract to perform the impossible, okay, which is absolutely void in the eyes of law. Yes, we understood consideration may be past, present, or future in the first point. We understood a consideration may not be inadequate in the second point, but we also need to know that consideration must be real and not illusionary. It is not something imaginary, something that is impossible by nature, right? You cannot make it possible by entering into a contract. For an example, if X promises to put life in the dead body of Y's son for rupees 1 lakh, the agreement is void. Now, what is X promising to do in this contract? Put life in the dead body. Can any human being do that? It is against the nature of law. Is that right? Nobody can put life or bring back a dead body to life. But here, X is entering into the contract with Y, telling that I will bring back your son to life if you will pay me rupees 1 lakh. This is completely unrealistic or just an illusionary. Got it? So therefore, in the court of law, the agreement stands void because the physical impossibility of the performance. So it's physically not really possible. It's beyond humans' power or beyond humans' capability to bring back a dead person's life again. So this is the third point. It must be real and not illusionary. Moving on to the fourth point, it must be lawful. Consideration must not be illegal, immoral, or opposed to public policy. Remember, whatever consideration you are paying or receiving in return for your promise in the agreement or contract, it must not be illegal. Something that government has banned or something that is not acceptable in the society or the public is going to oppose for it. If you're going to pay that as a consideration, then the court is going to make the contract void. If it has to be a valid contract, then the consideration must be lawful. Now, Indian Contract Act, according to or as per the section 23, it defines the consideration must not be forbidden by law. Okay, if consideration is forbidden by law, or it is any kind of fraudulent activities, or if the consideration is going to imply injury to the person or property of any other, under all these circumstances, the consideration is unlawful. Is that clear? Forbidden by law means sale of drugs, sale of weapons, correct? You are trying to print currency notes, which is only currency notes who can print? Only the Reserve Bank of India or the Ministry of Finance. Only they have the license or they have the authority to print or issue currency notes. If any other person, any other institution is doing the same by printing notes or issuing currency, it is forbidden by law. Nobody else has the power or the authority to issue currency notes apart from Government of India. Fraudulent, anything that is you are intending to cheat another person or fraudulent any kind of activities that is going to damage the other person's reputation or character or a property. Okay, any kind of fraudulent activities. Third, implies injury. So if you are entering into the contract and the consideration is you have to injure some person, you have to make sure you kill that person or you harm the other person, that is the return. If that is the return in the contract, then it is going to stand as void or unlawful in the eyes of the court. Or injury to the property of another. So if I'm entering, A is entering into the contract with B telling I'll pay you rupees 50,000 if you cause damage to the Mr. C's property. Now here, what is the consideration, what is the promise A is telling? I'm ready to pay you rupees 50,000, but only if you are ready to damage the property of Mr. C. Is that right in the eyes of law? No. You are nobody to damage or even touch a third person's property and enter into a contract for the same. The court says it is unlawful. Okay, so according to as per section 23 of the Act, the consideration should not be forbidden by law. It should not have any fraudulent intention, or it must not cause injury to a person or to a property of any other person. Okay, apart from this, you can have consideration. Example, A promises A promises to obtain B an employment in the government services, and B promises to pay rupees 50,000 to A. The agreement is void as the consideration for it is unlawful. Can you observe here? A promises to obtain B employment opportunity. Basically is telling, I'll give you, or I'll make sure you get a job in the government services, but provided you pay me rupees 50,000. Is this lawful? No. How do you get a government job? There is a procedure. Be it each department. Either it can be banks, either it can be KPSC jobs, or it can be administration jobs, post office. All this belongs to government authority or the control of government. If you need to get a government job, there is a procedure that the government has laid out. You need to clear some exam, some interview, some selection process. All this, unless you clear it and pass through the levels of interview, then you will be appointed as a government officer or a appointment under government authority. Laying all the selection process aside, if you're telling, I'll offer you a job only if you pay me a sum of money, which is unlawful and forbidden by the law according to the Indian Contract Act. Is that clear? That's your fourth point. Consideration must always be lawful. The fifth point, consideration may be an act, abstinence, or promise. As per the Act, consideration may be a positive act, a negative act, or a promise. Now, if you have come across previously in the introduction chapters where we came across about a positive offer, negative offer, remember that? Similar to that, here what we are discussing in consideration may be a positive act. Positive act means what? I'm going to perform something. There's going to be some action from one party. Okay, I'm going to conduct my behavior in such a way. So I'm going to do something that is called as positive. Negative act means abstaining from doing something, right? I will pay you rupees 10,000 if you would not build a border, or if you not build a border around your home. Is that clear? If you do not build a boundary around your home, I will pay you rupees 10,000. Now B didn't have to perform anything. He just had to abstain from performing something. You understand? He didn't have to build a boundary wall around his home. Okay, that is abstaining. That's called as negative act or a promise. Let's look at each one of them. Positive act. A requests B to sell and deliver certain goods on credit. B agrees to do so provided C guarantees the payment of the price. Here, sale of goods by B to A is the consideration for C's promise to guarantee the payment. Now, what is the contract? Between who two people are the contract here? A and B. What is the contract about? That B has to sell and deliver certain goods to Mr. A, but not on cash basis. A is not going to pay immediately. A is telling, you deliver the goods to me, but then I will pay to you on later time. That is basically I am taking the goods on credit. So B agrees to do so. B also says, yes, I am ready to sell you the goods on credit, provided Mr. C is going to promise the guarantee or guarantee the payment of the goods. Is that clear? So here the sale of goods by B to A is the consideration for C's promise to guarantee the payment. So B is ready to perform certain activity, or B is ready to sell his goods. He is performing certain action or certain activity in order to enter into the contract, or that is the supporting C's guarantee to the consideration will allow him to sell the goods to Mr. A. Is that clear? So B is performing certain activity which is called as positive act. Second, negative act. What is negative act? It's an abstinence. An abstinence refers to negative act. Not to do something is called as abstinence. Let's look at the example. X, the leader, entered into an agreement with borrower who is B. The loan becomes due. B fails to pay the loan. B promises to raise the interest from 10% to 12% per annum in consideration of a refraining from filing a suit against B for a year. Here, A's abstinence, that is not to file a case, is in consideration for B's promise. Now, who are the people in the contract here? X and B. Okay, these are the two people in the contract. Now, X has given some money to Mr. B. So, basically, B has borrowed money from X, and then B has failed to make the payment. So, the loan is due. Basically, has failed to make the repayment of the complete loan to Mr. X. So, what B promises here is, you gave me, I borrowed the money from you for 10% rate of interest. Give me 1 year's time. I will not pay 10%, but I will increase it to 12%. Okay, I will pay a little bit extra amount to you with 1 year's time, provided X will not file a case against B in the court of law. Is that clear? Now X, did he have to do something? Did he have to perform something here? No. He was supposed to abstain from performing or stop himself from performing. What would be the activity he is supposed to perform? Simply file a case against B for not repaying the loan amount he borrowed from X in the court of law. So what B says is, I promise to pay you extra percentage of interest and clear the loan. Give me 1 year's time, provided you will not file a case against me. Is that clear? So here A's abstinence, that is not to file a case against B, is in consideration of B's promise. Understood what is a negative act here? The last part, a return promise. In this, consideration may be a promise by one party in return of a promise by another party. Example, A agrees to sell his house to B for rupees 10 lakh. Here, B's promise to pay the sum of rupees 10 lakh is a consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay rupees 10 lakh. Here, both of them are to be competent. Now, who is the seller? A is the seller. What is he selling? A house. What is the price of the house? Rupees 10 lakh. To whom is he selling? B. Now, A selling his house will become a consideration for B, and B paying rupees 10 lakh will become a consideration for A. Is that clear? That is called as a return promise. A is ready to sell his house in case there is a return for him in the term of money for rupees 10 lakh. For B, B is ready to spend 10 lakh in case he only gets the house of Mr. A in return for his rupees 10 lakh. Hope you have understood a return promise. So today we learned about the second essential. Consideration need not be adequate to the promise. It must be real and not illusionary. It must be lawful. It may be act, abstinence or promise. Under that we have 3 acts: positive, negative and a return promise.